Let's go back to Parliament on the floor, where Speaker Alban Bagbin is currently addressing the censure motion in the House.
And most importantly, I am guided here by the standing orders of this House. The Constitution definitely is binding on me and all of us. So please allow the motion to be moved. Allow the motion to be moved. We discussed these things in conclave, and I was guided. This issue you are trying to raise now is a surprise. You should have raised it in conclave. I will not tolerate such things. Please allow the motion to be moved, and let's go on with what we agreed upon. Honorable Katie Hammond, you may move the motion now. But before you do so, please, I indicated earlier on that I myself will be making a formal communication to guide the House as the way forward. And I intend to do so now, because after the motion is moved, the understanding and the agreement in conclave is that we will take 5 members from each side of the House to contribute to the debate. 5 from each side of the House. And I have asked the leaders to give me the names of those who contribute. I have been given the names. I have. We also agreed that the Attorney General will participate in the debate as the Attorney General and Minister of Justice of this country. We further agreed on the minutes, and we agreed that each member will take 10 minutes. The leaders will take 20 minutes each. Leaders, 20 minutes each. Members, 10 minutes each. Then at the end of the day, I'll put the question. Let me read my formal communication. Honorable members, what I'm going to read is a very important statement. Lend me your ears. It is not only meant for the House, it's also meant for Ghanaians and the people. So we need to give at least some quietude for me to read this formal communication properly. Honorable members, I come under item 2 of the order paper to make this statement. I also seek refuge under Standing Order 71 of the Parliament of Ghana. The said order states as follows, and I quote, 71. Mr. Speaker may make statement on any matter of interest to the House. For the first time, this House is confronted with handling a motion calling on it to pass a resolution of a vote of censure on a Minister of State in accordance with Article 82 of the Constitution. Please, staff, leave the floor. You are talking to members and it's constituting a noise. For the first time, this House is confronted with handling a motion calling on it to pass a resolution of a vote of censure on a Minister of State in accordance with Article 82 of the Constitution and Orders 106 and 108 of the Standing Orders of Parliament. I am of the firm opinion that the procedure to adopt is a matter of interest to the House and of even more importance to the general public, whose interests we serve in this House. Furthermore, the novelty of the matter makes it compelling that I guide the House on the process and procedure to follow to resolve to pass or not to pass a vote of censure. Honorable members, it is my humble submission that a combined reading of Articles 93(1), 95(1), 101, and 102 of the 1992 Constitution, together with Standing Orders 5, 6, 8, 41, 1511, and 2, and the spirit and letter of the Standing Orders of Parliament in general. They define the composition of Parliament to include not less than 140 elected members and the Speaker of Parliament. Order 7 defines House to mean Parliament. Accordingly, the House is made up of not less than 140 elected members and the Speaker of Parliament. Honorable members, on Tuesday, 10th November 2022, the Minority Leader, Honorable Haruna Idrisu, moved a motion calling on the House to resolve to pass a vote of censure on the Minister for Finance, Mr. Ken Ofori-Atta, in accordance with Article 82 of the 1992 Constitution. The motion for the vote of censure was based on 7 grounds, as stated on the order paper. The Deputy Majority Leader, Honorable Alexander Kwamina Afenyo-Markin, raised a preliminary objection to the motion, contending that the procedure adopted by Parliament pursuant to Article 82 offends the ultra-virus and audio alteram partem rules. According to the Deputy Majority Leader, Parliament had no judicial authority or mandate to conduct investigation into the grounds stated in the motion as the basis for the vote of censure, since some of the allegations leveled against the minister border on the commission of a crime, and Parliament is not clothed with the mandate to conduct a criminal trial of any person. To the Honorable Deputy Majority Leader, what Parliament was invited to do by the Majority Leader, the Minority Leader, amounted to an invitation to conduct a criminal trial of the minister. Honorable members, those of you not listening, when in the debate you also get up, I will not listen to you, since you are not prepared to listen to me. The Deputy Majority Leader further contended that even if Parliament had jurisdiction over the matter, the minister responsible for finance is entitled to be heard in defense. He had to be put on notice by being served with the grounds for the vote of censure. In other words, the procedure for a vote of censure ought to provide a right to a fair hearing as guaranteed under Article 19 and 296 of the 1992 Constitution. Honorable members, you recall I straightaway overruled the preliminary objection. In my ruling on the preliminary objection, I indicated that it was not within my powers as Speaker to interpret the Constitution, but to apply it. Issues on constitutional interpretation and enforcement clearly belong to the remit of the judiciary and not the Speaker. I do not give reasons beyond this. What is, however, clear is that the process for a vote of censure is not a trial. What more, a criminal trial. It is a quasi-judicial process of a political nature and carries no legal consequences or liability, whether civil or criminal. Article 19 of the Constitution, which deals with criminal trials, is not thus applicable. Parliament is therefore intra-virus and not ultra-virus in admitting and permitting the minority leader to move the motion to invoke the powers of Parliament to resolve to pass a vote of censure on the Minister for Finance. On the issue of the authoritarian party rule, that is, listen to the other side or let the other side be heard as well, relied upon by the deputy majority leader as the basis for the preliminary objection, the provisions in both the Constitution and the standing orders of the House amply provide for it. The rules provide for an opportunity for the minister to be heard in defense. This formed the basis for my assurance to the House that the Honorable Minister responsible for Finance is entitled to a fair hearing and will surely be given ample opportunity to be heard in defense. Both the sponsors of the motion for the vote of censure and the minister will be given uninhibited opportunities to put across the reasons for and against the motion to enable the House to take the vote. In accordance with Standing Order 86, I inquired to know whether there is a seconder to the motion. Honorable Mohammed Mubarak Muntaka, the minority chief whip, seconded the motion. After the motion had been seconded, I decided to refer the matter to an ad hoc committee and in consultation with the leaders, constituted an 8-member ad hoc committee to inquire into the matter and report to the House within 7 working days for debate and vote. I had to take 7 working days based on the consultation I had with leaders. And the membership were proposed by leaders. Honorable members, you will recall the referral of the matter to the ad hoc committee was vehemently objected to by some members of Parliament and the public. This school of thought opined that the procedure adopted by me was irregular and unsupported by law, and insisted the debate on the motion should proceed and be taken the same day. Honorable members, the call for a vote of censure is novel in this Parliament. What I sought to do, after extensive consultation, was to provide a procedure to guide the House. I am convinced my decision to refer the matter to a committee of the House is the right thing to do. And now I proceed to refer to the facts and the law in support of this decision. On the question of facts, the preceding consultations with leadership of both sides of the House revealed that the minister was out of the jurisdiction of this House, that is on the 10th of November 2022, on official assignment, and could therefore not be present in the House. The absence of the minister was also visibly loud and manifest on the floor of the House that day. How could the debate proceed and end that day without the minister being given the opportunity to be heard in defense before the vote is taken that day. On the question of law, Order 1061 is clear. It says, and I quote, "The House may pass a resolution to remove the President, the Vice President, Mr. Speaker, and Deputy Speakers, and a vote of censure on a Minister of State. The House may consider such motion and come to a decision or refer it to a committee on a motion made by any member." Honorable members, emphasis is on a committee. And note the spelling of the committee starts with a capital C. There is no such existing committee on motions to pass a resolution to remove or on a vote of censure on a Minister of State. Therefore, I am of the view that a member could not have moved a motion to refer the matter to a non-existing committee. And so I proceeded in discussion with leaders to set up an ad hoc committee. The Constitution and the Standing Orders of Parliament have provided a solution in the absence of such a committee, and I will deal with that shortly. Honorable members, it is important to draw your attention to this underlying guiding concept of the custom and law of Parliament and the underpinnings of parliamentary practice and procedure. The law and custom of Parliament and parliamentary practice and procedure are more in the world of politics than law. The law is in the bosom of the judge and not Parliament or the Speaker. The reason why judges are referred to as the law lords. Politics is in the bosom of the polity, the community, the society, the people. Parliament is the house of the people, and parliamentarians are the representatives of the constituents, the people. But the House must perform its functions and conduct its mandate in accordance with the provisions of the Constitution, the standing orders, and what is generally referred to as the law and custom of Parliament. Parliament must provide unlimited opportunities for open debate in consonance with the rights and freedoms, privileges, and immunities of members and officers of the House. Honorable members, a careful reading of the rules of procedure set out in the Constitution and the standing orders leaves nobody in doubt that there are legal prerequisites before a motion to consider a vote of censure is admitted. To paraphrase the prior requirements for the admission of such a motion, the law says a motion for a resolution to censure a minister under Article 82 shall, 1, be signed by not less than 1/3 of all the members of Parliament, and 2, be received by the Speaker. But before such a motion could be moved, after being admitted, 2 further requirements must be complied with. 1, 7 days notice should have been given of the motion. And 2, the motion shall be debated within 14 days after the receipt by the Speaker of the notice for the motion. A notice of a motion is received by the Speaker when it is acknowledged in the office of the Speaker as so received. A notice of a motion is received by the House when the motion is published on the order paper of the House as notice of motion. All these prerequisites and prescriptions were meticulously followed and complied with. in consultation with leadership of both sides of the House, the 14th day after receipt of the motion by the Speaker fell on the 10th of November, 2022. The motion of censure was thus programmed and published on the order paper to be moved on that day. Honourable members, controversy emerged on the procedure to adopt to provide a fair opportunity for the minister to be heard in defence. The disagreement centered on the import of Clause 4 of Article 82, which states that, I quote, "A minister of state, in respect of whom a vote of censure is debated under Clause 3 of this article, is entitled during the debate to be heard in his defence," unquote. It's important to note that Article 82, Clause 3 of the Constitution specifies that the vote of censure shall be debated by the House. This constitutional provision is repeated in Order 108B of the Standing Orders of the House. A minister of state in respect of whom a vote of censure is debated is thus entitled to two procedural rights. One, he is entitled to be heard in defense. And two, he is entitled to be heard during the debate. Insofar as debates in Parliament are concerned, Article 101, 110, and 111 of the Constitution and Order 86 of the Standing Orders of Parliament set out in great detail the rules which regulate debates in this House. A reading of the order and the Constitution will leave no doubt in anybody's mind that it provides only for members of the House, and by virtue of Article 111 of the Constitution, includes the Vice President or a minister or deputy minister who is not a member of Parliament. These are the only persons who are allowed to speak and debate during plenary sittings of the House. Defined by Article 2951 of the 1992 Constitution and Standing Order 7, sitting includes a period in which Parliament is sitting continuously without adjournment, and a period during which it is in committee. Honourable members, all other persons outside this category are referred to as strangers. Defined by Standing Order 7, stranger means any person other than the President, Vice President, Mr. Speaker, ministers and deputy ministers who are not members or officers of the House. Clearly, this standing order has included the President and Mr. Speaker. But in the case of Mr. Speaker, Standing Order 90 settles the matter. It says, Mr. Speaker shall not take part in any debate before the House. So Mr. Speaker is excluded. It's only the President that is added to the number in 111. As to whether the standing order is right or wrong, it's not for the Speaker to decide. Honourable members, both the Constitution and the standing orders require that the minister against whom a vote of censure motion is moved is entitled, and I repeat, entitled to be heard in defense. What does to be entitled to be heard in defense mean? And how is Parliament to make rules for the practice and procedure for the minister to be heard in defense? Back benches. Honorable members, there is not much procedural guidance in both the Constitution and the standing orders on the issue of a vote of censure on the Minister of State, apart from the TERS framework captured in Article 95 and Orders 106 and 108 of the Standing Orders of Parliament. In the case of the removal of the President, Vice President, Speaker, and Deputy Speakers, an elaborate procedure has been detailed out in both the Constitution and the Standing Orders of the House. Members may read both Articles 69 and 95 of the Constitution and Orders 106(2) and 107(1) of the Standing Orders of Parliament. Honourable members, time will not permit me to go into detail, but suffice it to say that in both situations, the phrase "to be entitled to be heard in defense" is repeated. For instance, in the case of the removal of the President, Article 69, Clause 7 states as follows: 697, the President shall be entitled during the proceedings of the tribunal or of the medical board to be heard in his defense by himself or by a lawyer or other expert or person, as the case may be, of his own choice. This provision is repeated in the Rules of Practice and Procedure in the Standing Orders, and that can be found at Order 1062, who says, a motion for resolution to remove from office the President or Vice President shall, during prior proceedings in a committee appointed in that behalf, the President or the Vice President shall be entitled to be heard in his defense either by himself, by counsel, or by an expert, as the case may be. In the case of the Speaker or Deputy Speaker, the Constitution is not so elaborate on the practice and procedure of removal. See Article 95(2) of the 1992 Constitution. The Standing Orders of Parliament has, however, taken care of that procedure. Order 1031C says, and I quote, prior proceedings shall be taken in a committee appointed in that behalf. The Speaker or the Deputy Speaker shall be entitled to be heard in defense, either by himself or a representative. So, President, Vice President, Speaker, Deputy Speaker, there is a committee set up. They have to appear before the committee, they are heard, and they have to appear to defend themselves in the House. They are qualified by law to do so. Such a provision is absent in the proceedings of a vote of censure on a Minister of State. Both the Constitution and the Standing Orders of Parliament do not provide for such an elaborate procedure. The Constitution and the Standing Orders simply say, in Article 82(4), that a minister is entitled during the debate to be heard in his defense. And Order 108 say, during the proceedings on the motion, the minister shall be heard in his defense. Honorable members, it is my humble view that in such a situation, I am called upon as the Speaker to perform my duty to provide for such a rule or procedure not provided for, in accordance with Order 6 of the Standing Orders of this House. And Order 6 says, in all cases not provided for in these orders, Mr. Speaker shall make provisions as he deems fit. Honorable members, let's ponder over these issues. 1. How could Parliament be seen to have given the Minister a fair hearing in the motion to pass a vote of censure without an inquiry into the grounds on which the motion is based? Can the minister's lawyer or expert participate in plenary debate as counsel or expert in the exercise of the minister's right to be heard in defense when the counsel or expert is not a vice president or Mr. Speaker or deputy speaker or minister of state or member of parliament, but a stranger? 2, can members of parliament or the minister during a debate at plenary tender documents, records, books, or be cross-examined in the course of such debate? Can the minister's lawyer raise objections during such a debate and cross-examine people? That is not practicable by the practice and conventions of the House. And I refer to the Constitution and the standing orders. Honorable members, Orders 106, 107, and 108 of the Standing Orders of Parliament admit of a situation where the House or a minister in respect of whom a vote of censure is to be passed summons or calls witnesses in accordance with the provisions of Article 1036 and 121 of the Constitution, and Standing Orders 201, 202, 203, 204, 205, 206, and 207 to attend or be compelled to attend to be examined on oath, affirmation, or otherwise, and to give evidence or to produce a paper, book, record, or other documents before the House. Such a witness is entitled, in respect of his evidence or the production of the document, as the case may be, to the same privileges as if he were appearing before a court. That is in our standing orders. It is not Mr. Speaker saying it. Please, let us again ask ourselves, can this be done in the course of a debate at plenary? The answer is obviously no. It cannot. It is in the light of the above that upon consultation with the leaders of the House, I decided to adopt the rules of practice and procedure in respect of the phrase "to be heard in defense," and laid out in the Constitution and the Standing Orders in the case of the removal of a president, vice president, speaker, or deputy speaker. I read the absence of such rules in the Standing Orders in the case of the vote of censure on the minister as an oversight. Honorable members, I am of the firm opinion that equal opportunity will be provided in such a situation for both the proposers and the minister to detail out the facts supported by the necessary documents on which it is claimed that a resolution on a vote of censure be passed against the minister, and the minister to be heard in defense during the proceedings and debate on the motion. It is informative to note that under Standing Order 201, a committee shall have power to request the Attorney General to attend upon it to give assistance, and a witness before any committee may also be represented by counsel. Any witness before any committee is by our law allowed to be represented by a counsel. Honorable members, the House has not appointed any committee on this subject matter. The House is yet to establish a specific committee to do so, as has already been done by other parliaments, even in Africa. They have committees, standing committees, select committees on vote of censure, on impeachment of presidents, and the rest. We haven't established any, or to use the term in the standing orders, we haven't appointed any such committee as at now. The process we are developing now, in my humble view, will be of immense assistance to Parliament in its ongoing efforts to revise the standing orders of the House. I will now conclude. Honourable members, the information I have shared with you and the public leaves me in no doubt whatsoever that the procedure adopted by the referral of the matter to the ad hoc committee for inquiry is well rooted in law. I am convinced that the public hearing conducted by the committee has vindicated my decision and allayed the fears of all those who are thought otherwise. Fortified by this conviction, I rule that the referral of the motion to pass a resolution on a vote of censure on the Minister of Finance to an ad hoc committee for inquiry is proper and in accordance with the law. Honourable members, the House may now proceed to debate the motion. And I want to thank you for the audience and invite the chairman, who I'm told is Honourable Katie Hammond, to move the motion. Yes, Honourable.
Thank you very much, Speaker. Mr. Speaker, I need some assistance from the Speaker before I proceed. Mr. Speaker, it's a 43-page document. I'm wondering how to handle it, considering
Honourable member, I can't hear you.
Yeah, Mr. Speaker, I said I needed some clarification. It's a 43-page document. I didn't think that we'll be able to read everything, so I was wondering if I could skip as I go over or just introduce the salient part of it and then the
Honourable member,
Mr. Speaker.
You are a very senior member of this House.
Mr. Speaker.
And you have also assumed the title Senior Prefect.
Correct.
You know how to move a motion.
Mr. Speaker, it is because of the exceptional nature of this, as you indicated.
Honourable member, a motion is a motion.
Thank you, Mr. Speaker.
Move it accordingly.
Mr. Speaker, I beg to move the motion as identified at page 16 of the order before for today, and it's numbered as 21. And it is this, that this Honourable House adopts the report of the ad hoc committee on the motion of censure against the Honourable Minister for Finance, Mr. Ken Ofori-Atta. Speaker, I now proceed to present the committee's report. Mr. Speaker, Parliament of Ghana, at its 11th sitting held on Thursday, the 10th of November 2022, considered the motion moved by the Honourable Minority Leader, Mr. Haruna Idris, seconded by the Honourable Minority Leader, Honourable Minority Chief Whip, Al-Haj Mohammed Mubarak Mutaka, calling on the House to pass a vote of censure on the Honourable Minister responsible for Finance, Mr. Ken Ofori-Atta, pursuant to Article 82 of the Constitution. In accordance with Order 1061 of the Standing Orders of Parliament, the Right Honourable Speaker referred the motion to an ad hoc committee for consideration and report. The purpose of the referral, as stated by the Right Honourable Speaker, is to provide a forum for the Honourable Minister of Finance, who is the subject matter of the censure motion, to defend himself in accordance with Article 82(4) of the Constitution. Article 82(4) of the Constitution reads as follows. A Minister of State in respect of whom a vote on censure is debated under Clause 3 of this article is entitled during the debate to be heard in his defense. In making the reference, the Right Honourable Speaker stated as follows. Let me assure all of you that the Honourable Finance Minister would be given ample opportunity to defend himself. The matter will be referred to an ad hoc committee to investigate, where the Honourable Minister would have the ample opportunity to defend himself. The evidence will be placed before the committee. The Honourable Minister would have the opportunity to defend himself. A report will be presented to the House, and we would debate that report. He further stated, a witness can come with counsel. We want a person to be heard properly, and I do not think that it can be done here. All that you have stated here are allegations. When you appear before the committee, you will now produce the evidence, and the minister would counter. The committee was given 1 week to present its report to the House. The grounds of the motion moved by the minority leader and seconded by the Honourable Minority Chief Whip are as follows. That this Honourable House passes a vote of censure in the Minister responsible for Finance, Mr. Ken Ofori-Atta, in accordance with Article 82 of the 1992 Constitution on the following grounds. Number 1, despicable conflict of interest, ensuring that he directly benefits from Ghana's economic woes, as his companies receive commission and other unethical contractual advantage, particularly from Ghana's debt overhang. 2, unconstitutional withdrawals from the Consolidated Fund in a blatant contravention of Article 178 of the 1992 Constitution, supposedly for the construction of the President's Cathedral. 3, illegal payment of oil revenues into offshore accounts in a flagrant violation of Article 176 of the Constitution. 4, deliberate and dishonest misreporting of economic data to Parliament. 5, physical recklessness leading to the crash of the Ghana cedi, which is currently the worst performing currency in the world. 6, alarming incompetence and frightening ineptitude resulting in the collapse of the Ghanaian economy and an excruciating cost of living crisis. 7, gross mismanagement of the Ghanaian economy, which has occasioned untold and unprecedented hardship. Membership of the committee is as follows. My good self as senior co-chair, Honorable Dominic Ayini, Doctor, as Dominic, junior co-chair. Dominic, co-chair. Honorable Patrick Yabuama, member. Honorable Kwame Imedu Entry, member. Honorable Kofi Agapa Mensah, member. Samuel Okujetua Blokwa, member. Honorable Senator Ajiman Rollins, member. And the Honorable Bernard Ahiafo, member. Mr. Camilo is the chairman of the committee. I will not go through the methodology. The proceedings. Mr. Speaker, in the conduct of these proceedings, the committee, Speaker 1, examined material evidence tendered, invited the proponents of the motion to state their case, with the principal subject of the motion, the Finance Minister and his counsel in attendance. 3, transmitted a verbatim transcript of the proceedings together with all the documents tendered to the minister to aid in the preparation of our defense. 4. Invited two institutions, PIAC and GMPC, to either corroborate or deny some evidence before the committee. 5. Took oral evidence from the Minister of Finance, the principal subject of the motion, aided by his counsel in answer to terms of the motion and evidence adduced, and examined written and oral evidence adduced by the witnesses. Mr. Speaker, as I indicated, it's a 43-page document. I would ask that the Hansard captures the entirety of the report whilst I proceed to the very end of the report. The very last, what we describe as conclusion, is that the committee, having regard to the provisions of Article 82(4) of the Constitution and Order 1061, and the direction from the Speaker, duly offered the Honorable Minister of Finance the opportunity to be heard in his defense. The Minister was represented by counsel. The committee accordingly submits for the consideration of the House the representations by the proponents of the motion and the responses of the Honorable Minister in his defense. Respectfully submitted, Mr. Speaker. Mr. Speaker, before I resume my seat, as a matter of footnote, just to add that there is an Appendix 1 which itemizes the items, documents we looked at, and then critically Appendix 2, which captures the entirety of the responses provided by the Honorable Minister to the allegations leveled against him. Thank you very much, Mr. Speaker.
Honourable members, it's now the turn of the Honourable Dr. Dominic Ayine.
Thank you very much, Right Honourable Speaker. Right Honourable Speaker, I rise to second the motion ably moved by the Honourable Member for Adansia Sopa, my very good friend, the Honourable K.T. Hammond, the senior co-chair, as he has named himself this afternoon. Mr. Speaker, I want to thank leadership for the opportunity to work on this committee. The reason being that, Mr. Speaker, in the life of this Fourth Republic, as you have rightly pointed out, this committee is a novelty. And when, Mr. Speaker, constituted a committee, you did something that I thought was going to work well in terms of the way we work in this parliament. That is, giving us the opportunity to build consensus. There were 4 members from the majority and 4 members from the minority. And I knew, as co-chair, that the only way we could make progress was for us to build consensus, in line with the spirit behind the constitution of the committee. We did our best in building consensus, and the report that has been presented this morning and this afternoon is as a result of the consensus building. But, Mr. Speaker, there were drawbacks in our attempts to build consensus. One such drawback was the fact that every contentious issue that came up, we on the minority side were often reluctant to propose that a vote be taken. Because by the rules and practices of this House, when a vote is tabled and then there is a tie, it means that you have lost the vote. So we were compelled all the time to build consensus. And one of the drawbacks that I want to highlight as far as this report is concerned is the fact that in terms of its substantive content, we could not make definitive findings of fact and recommendations. Mr. Speaker, I had thought that the mandate of the committee was a fact-finding committee, and therefore we could make findings of fact. That was vehemently opposed by the majority. And because of that, you will notice that in terms of its substantive content, the report does not have real findings of fact, definitive findings of fact, as well as recommendations. Mr. Speaker, there were a number of things or misimpressions that were said about the work of this committee that I would want to highlight. Mr. Speaker, Parliament is not an administrative body. And because Parliament is not an administrative body, Parliament is not subject to Article 23 of the Constitution, which guarantees the right to administrative fairness or administrative justice. Mr. Speaker, the drafters of the Constitution, in their wisdom, guaranteed the right to political fairness under Article 82, Clause 4 of the Constitution. And as Mr. Speaker has said, whereas the law is in the bosom of the judge, politics is in the bosom of the polity. And we are the polity as the representatives of the people. And therefore, Article 82(4) guarantees the right to political fairness, fair treatment of the minister during the course of debate when a vote of censure has been tabled in respect of any minister. Mr. Speaker, in the course of the work of the committee, two of the grounds that had been stated in the motion became the subject matter of controversy. One of the grounds related to the issue of conflict of interest. And Mr. Speaker, there was a preliminary objection that was raised by counsel for the minister. That preliminary objection flowed from the fact that in the course of testimony by the Honorable Minority Leader, the Honorable Haruna Idrisu, in relation to the work that the committee was doing, the Honorable Haruna Idrisu referred to Article 103, Clause 3 of the Constitution. And he said, the committee was cloaked with jurisdiction in order to inquire into or investigate matters relating to the activities of ministries. And he rightly observed that the issue of conflict of interest by a minister relates to activities undertaken by that minister at his ministry. And therefore, it fell right within the ambit of the jurisdiction of committees of Parliament. In response, counsel for the minister challenged our jurisdiction and referred to the case of Samuel Okudzeto Blakwa and another person, an attorney general, and stated that on account of that case, we did not have jurisdiction. Mr. Speaker, when we looked at the challenge, we took account of the fact that the principle of law is very clear, that where general powers have been granted to a body, and specific powers have also been granted to another body in relation to the same matter, the general should not detract from the specific. That is the principle of law. And we thought that there was a legitimate constitutional issue that was raised. And we agreed that the matter be referred back to this House for debate. Mr. Speaker, in coming to agreement on this matter, I was mindful of the ruling of your predecessor, the Right Honorable Do Ajahu, in a motion that was brought before this House on the first day of September 2016. And that was a motion for Parliament to inquire into allegations relating to the so-called Ford expedition matter. Mr. Speaker, the Hansard records your predecessor are saying as follows. He said, Honorable members, Since the case of Samuel Okudzeto-Ablakwa and Dr. Omani Boama versus Jake Otanka Obichebi-Lamte and the Attorney General, this House is bound by interpretations put on the Constitution by the Supreme Court. It is my view, therefore, that STRIKE is the institution vested with the exclusive constitutional authority to deal with all relevant matters relating to breach of code of conduct for public officers, including the matter on the receipt of the Ford Expedition vehicle. Furthermore, as indicated earlier, STRIKE also has jurisdiction to investigate all matters of corruption and abuse of power. Mr. Speaker, on account of this observation, the Right Honourable Joe Ajaho did not allow for debate to proceed in respect of the petition, the motion that was brought before this House. Mr. Speaker, as far as we were concerned, this is a quintessentially political matter, and therefore we would not say that Parliament should be precluded in debating the matter. However, we think that once the matter has been raised at committee, it should be referred to the House for decision. That was the basis of our decision that the matter be referred back to this House. Mr. Speaker, let me indicate that there has been some misrepresentation out in the media that the two grounds were struck out. As a committee, you do not have the mandate to strike out the grounds of a motion that has been referred to you by the plenary. And therefore, we could not have taken upon ourselves to strike out the two grounds. In respect of the ground relating to, that is ground 3, relating to legal payments, we came to the conclusion that that transaction involved essentially a transfer of funds by Talo Ghana Limited to the offshore account of Jubilee Holdings, a subsidiary of GNPC. And in that wise, we said the minister was not to be called upon to answer questions in respect of that particular ground. Mr. Speaker, I wish to state categorically that this report, as well as the work of the committee, found as a matter of fact as follows. For instance, on ground 1, funding of the National Cathedral, it was very, very clear that the minister exceeded what was appropriated. In other words, he engaged in expenditure in excess of appropriation. That is because, according to the minister in the report, he took the money from other government obligations. And it was a contingency vote. Now, if you look at the other government obligations and the vote that this House passed for other government obligations for that fiscal year, it was very, very clear that the minister, by his own evidence that he submitted to us, exceeded appropriations. In fact, the minister spent for that year, he spent 339 million Ghana cedis on the cathedral, and that was far in excess of the envelope of resources that we appropriated for other government obligations. Mr. Speaker, it was also very clear, and it is found in the report dealing with misreporting of data.
Honorable member, just a minute. The first point you just submitted, I've been trying to get the evidence on the report. So just draw my attention to it. I'll take note of it, then we'll move on to a second part, which I've referred to the report again. Then I can take note of them.
Good. Okay, you're fine. Mr. Speaker, if we turn to page 14 of the report of the committee, it says that the committee, pursuant to the above agreement, formally requested for the said information, and the minister duly complied. The amount spent between 2019 and March 2022 was 339 million. So, Mr. Speaker, this was what was found by the committee. And if you compare that amount to what was voted and appropriated by Parliament, it is far in excess of the approved amount for purposes of the National Cathedral construction. Mr. Speaker, in respect of misreporting of data to Parliament, we found, as a matter of fact, that the minister did misreport matters to Parliament. For instance, in 2008, he reported a fiscal deficit, he reported a fiscal deficit of 3.8% instead of 7.1%, by excluding an item of expenditure amounting to 9.8 billion in order to be able to underreport the fiscal deficit. Also, in 2019, he reported a fiscal deficit of 4.8% of GDP instead of 7.1% of GDP. Instead of 4.5% of GDP.
Honorable Doctor, I cannot ignore him. So you just hold on. Let me hear what he wants to say. Yes.
Mr. Speaker, what my colleague is doing is rather troubling. What the Honorable Co-Chairman is doing is troubling. Mr. Speaker, when I started the presentation of the report, I did indicate that there weren't any recommendations. What happened was that the proponents...
Actually, he's not talking about recommendations.
The proponents of the motion were allowed to present their case. Mr. Speaker, the Honorable Minister was then, pursuant to the instructions given us, was allowed to give or lead his own evidence, Mr. Speaker, in his own defense. And so we presented the case as it is. The report is posited this way. Is the presentation or the evidence led by the proponent. Mr. Speaker, unadulterated. We left it as that, and then the ministers was also left in situ. No findings of fact. The recommendation we made, Mr. Speaker, is at the tip end of it, which is only about 2 lines. So I'm not so sure what my colleague is doing, that we made a finding, there's a finding, there's a finding. There isn't one single finding, Mr. Speaker, by your committee.
Honorable member, that is your story. We are listening to his story. We have the story of the committee, and we are taking note of his story and your story vis-à-vis the story that the committee has presented to us. And so we are taking note of what is in the committee. So if he says something and it is not in the committee's report, we will take note of it. And if he also says something which is not in the committee, we will take note of it and we know how to handle that. Please. You are seeing things from different perspectives, but the committee's report is there for us. We are being guided by the committee's report. Yes, that's what we are looking at. That is why I asked him to draw my attention to the figures. So wait, I'm listening to him here.
But is it a finding?
Honorable member.
Yes, Mr. Speaker.
I don't think that being a senior prefect amounts to you challenging the speaker.
Mr. Speaker, that's the last thing I would ever do, to challenge the Mr. Speaker, just seeking clarification so that I'm clear in my mind. But I think he's seriously misleading the House.
I am taking note.
Thank you very much.
And you are all taking note.
Senior prefects, they have privileges.
The minister will be given the opportunity. The minister is also going to be given opportunity. So please, let's allow each other to flow. We'll listen to each other. At the end of the day, we'll take the vote. Yes, Honorable Dominic Ayine, you may continue.
Yes. Mr. Speaker, the fact that we didn't make the definitive findings of fact does not mean that the evidence adduced by the committee is not before this House. Mr. Speaker, we have the transcripts of the verbatim transcript. And I do remember, as co-chair, listening to the Honorable Minister say that yes, he did report those figures to Parliament, except that he is entitled by the rules of accounting, the international rules of accounting, to report below the line. That is what the minister told us. And the minister is here. I'm not lying for him. I'm not lying, about it. So, Mr. Speaker, the evidence is here. And our report is to enhance debate. So I'm drawing attention to what was, stated in the reports and the transcript. So, Mr. Speaker, on the issue of fiscal recklessness, it was very, very clear also that even given the figures that I have cited, that the minister had engaged in fiscal recklessness. Mr. Speaker, I want to conclude by making it very clear that the report of this committee has found unassailable evidence of misconduct on the part of the minister. It has found, even if it has exonerated the minister on some grounds, it has found that the minister misconducted himself with respect to a lot of grounds. Yes. And as I've stated, there is unassailable evidence of misconduct on his part. On the basis of this, Mr. Speaker, I am calling on honorable members of this House, in line with Order 108 of the Standing Orders, 108B of the Standing Orders of Parliament, and Mr. Speaker, with your permission, I shall read. 108 says that a motion for a vote of censure on a Minister of State shall be moved in the following manner. And B says, the motion shall be debated in Parliament within 14 days of its receipt by Mr. Speaker, and shall be supported by the votes in secret ballot of not less than 2/3 of all the members of Parliament. In the circumstances, Mr. Speaker, I call on members that we do a secret ballot in which we will decide whether or not we are persuaded by the evidence in order to remove the minister. I so second the motion, Mr. Speaker.
Honorable members, the motion for the House to resolve to censure the minister was moved by the minority leader and seconded by the majority chief whip. We referred it to the committee. What we did is to allow the co-chair to actually put a report before the House. And so we will now proceed to the debate where the submissions of the mover of the motion, the seconder, together with the reports that we have, will now be debated on by the House. By the spirit of this House, and that is the reason why the arrangement is made this way, horseshoe arrangement, is to get us to first focus on building consensus. It's when consensus fails that you put the issue to vote, which is the second principle of democracy. The primary principle of democracy is that anything that concerns any person, the person must participate in the decision-making process. So when that fails, then you go to the second principle. So the setting up of the committee was based on this principle that we adopted, our founding fathers adopted by this arrangement. That's why you don't see the arrangement in this House like that of the House of Commons. Because the first thing is to build consensus. And so we proceed to debate the matter as we presented before the House. Now, from the majority side, we will invite Honorable Alexandra Afenyo Markin.
Mr. Speaker, thank you for the opportunity to add my voice to the motion before the House. Mr. Speaker,
you are aware you have 10 minutes. You are aware you have 10 minutes.
Mr. Speaker, this opportunity afforded me to comment on this motion. And in commenting on the motion, I would make certain observations, which observation to me renders the whole exercise by the applicant odious, and that it is only aimed at going very political against the Minister of Finance, and the grounds upon which they relied to proceed indeed was political. And it's obvious from the conduct of the proponent, including the co-chair who just seconded the motion. Mr. Speaker, in the words of the co-chair of this motion, he argues that the committee is not a quasi-judicial body. Neither is it an administrative body, but that the committee is engaged in a political process. These were his words. So, Mr. Speaker, it is now up to us as a House to ask a question whether a mere political process is a means of indicting a public officer. Mr. Speaker, this is a committee that could not come out with findings of fact in the words of the co-chair who seconded the motion. Where are your findings? You said that you have unassailable evidence. You said that you've heard from the proponent. Suffice to say that you yourself, you were a judge in your own cause. You were a member of the group that applied to Mr. Speaker to move this motion, and then you also sat as a co-chair of the committee. That is what happened. And then you are telling us that you could not come out with findings of fact. The lawyer in you prevented you from saying something negative, but the politician in you compelled you to say that the minister should leave office. Mr. Speaker, clearly, all your allegations had no leg to stand. All your allegations stood on stilts, and you yourself, you were candid. Honorable Dr. Ayeni, you were so candid in your submission when you said that you were relying on Dor Ajaho ruling, which ruling has stopped this House from considering a matter grounded in Article 287 of the Constitution, conflict of interest. If that is the case, if you know that there's a ruling that outs the jurisdiction of this House when it comes to conflict of interest, why then did you proceed to make comments on conflict of interest? Why then didn't you advise your colleagues that issue of conflict of interest could not be part of your grounds before this House? Mr. Speaker, I dare contend that should we proceed to vote on this matter, we will be setting a bad precedent. We will be setting a bad precedent which will come to haunt this House one day. Because, Mr. Speaker, the Minister of State, the Finance Minister, has not been indicted in any way. What will be the basis for a vote? What will be the basis for a vote when a committee is unable to come out with a finding to indict him, which is the basis for what we call a prima facie in law? Mr. Speaker, the former Deputy Attorney General, who was privileged to be a co-chair, knows his law. And he knows that the law that he celebrates so much allows him to do that which is just, fair, and right. In his own words, he said that the committee's work was not in any way bound by Article 23. Did I hear him right? You are saying that a matter that you are indicting your fellow citizens in public office, you are not bound by Article 23. What else would you be bound by? The requirement that expects you to be fair, the requirement that expects you to be candid, the requirement that allows you to follow due process, you said that you are not bound by it. These were your position. And you are saying that it's a political process. A political process that allows NDC minority group to get up as it pleases them to say that no, there is a political decision to take. So we are proceeding with a political decision. So we are not bound by the rules of natural justice. We are not bound by the rules of fairness. These were your arguments. Mr. Speaker, an invitation as dangerous as this will lead us into a valley that we may never be rescued. And Mr. Speaker, we should make no mistake. We should make no mistake. If we follow such a dangerous path, the politics of this country will be condescending into a level that, Mr. Speaker, it will be very unattractive to any person who desires to serve his nation to proceed wholeheartedly to do so. Mr. Speaker, if Harun Edrusu were the one facing such a matter, would he be happy? If Dr. Ayeni was the one being subjected to such an ordeal, would he be happy? If Muntaka Mubarak were the one being subjected to this ordeal that we are told, fairness does not matter. The need to establish a prima facie does not matter. Would he be happy? He will not be happy. The minority should know that what is good for the goose is good for the gander. Will Atufosin be happy if one day he's called upon and told that you are a finance minister? Atufosin, there's no need to establish a prima facie, but the economy is going bad. Therefore, a censure motion is to be carried against you. Would you be happy, Atufosin? Or you will? Mr. Speaker, they are acting in bad faith. But I want to tell them that our side will not support that path. We will not support them. We will never support you. But we want to take this opportunity to tell you that what you're doing is wrong. Mr. Speaker, in any event, let me talk a little bit of law here. Article 82(3) is clear. And Mr. Speaker, I would want to state it for the records. The provision of the Constitution talks about 14 days for debate to be Mr. Speaker, for the debate to be carried, Mr. Speaker, when the motion is filed. Mr. Speaker, for the avoidance of doubt, and for those who have decided to be shouting instead of paying attention to the argument, Mr. Speaker, this is what the Constitution says. The motion shall be debated in Parliament within 14 days after receipt of the Speaker of the notice for the motion. Mr. Speaker, my humble understanding, and I'm adding it as part of my argument, my comment in this matter. My humble understanding is that the process of a committee being set in motion, the process where the report of the committee is to be heard, and the period within which the debate is supposed to take place must all be within 14 days. But I concede, Mr. Speaker, that you don't interpret the Constitution.
Amen.
I do consider, Mr. Speaker, you don't interpret the Constitution. But I am raising this as an observation.
I want to hear you again. Are you saying that they all have to be done within 14 days?
Mr. Speaker, with the greatest respect, at the risk of being repetitive, and in response to your question, let me read and then explain again.
No, you don't need to read.
Oh, Mr. Speaker, for emphasis.
Please, your submission. Are you saying that all that has to be done within 14 days.
Because this is what it says. The motion shall, the motion.
I'm not talking about the Constitution. I've read it many times. I'm talking about what you said.
Mr. Speaker, what I am saying is that by necessary implication and by the express import of this provision, that is what it says. Mr. Speaker, by the express import of this provision, and I will read it for emphasis, the motion shall be debated in Parliament within 14 days after the receipt by the Speaker of the notice for the motion. In other words, all procedural imperatives required for this motion to become right must be within 40 days, and I dare contend on that. You may disagree with me. I dare contend on that.
Honourable Member, that is why the motion was moved within 14 days on the 10th. Your interpretation of the Constitution is not the law. Please. Your interpretation, Minister for Communication, I can hear you loud and clear. You are not in charge here. Please. That is your understanding. You are permitted to go on. So you go on.
Thank you, Mr. Speaker. Mr. Speaker, I claim your attention for some rescue. The members may have to listen to me in silence. Mr. Speaker, there's too much noise on the other side. Mr. Speaker, the minority must hear me in silence. They are making too much noise. Mr. Speaker, the point is, the provision is mandatory that shall be debated within 14 days. Mr. Speaker, so the shall is mandatory. And I am adding it as part of my submission that to the extent that Parliament could not meet this constitutional requirement, all that we are doing, Mr. Speaker, if care is not taken, will become ultra various of the Constitution. Because, Mr. Speaker, we do concede ab initio. Mr. Speaker, we did concede ab initio that there was no such procedure in place. That is why, Mr. Speaker, you set a motion in place to allow a committee to even hear the minister.
Honourable Member, your time is up.
Mr. Speaker, let me conclude.
I gave you more than 10 minutes. It's there. I'm watching my lesson. I'll give you more than 10 minutes. So I gave Honourable K.T. Hammond a time, and I gave the same time to Honourable Dominic Ayine. But the rest, you as part of leadership agreed with me. That is 10 minutes each. I have given you 11 minutes, 50 seconds. So please, I am fair. Resume your seat. It's now, honourable members, the turn of Honourable Isaac Adongo.
Thank you very much, Mr. Speaker. Mr. Speaker, I am surprised that even as a layman, I seem to know the law better than what I just said. Mr. Speaker, the motion of censure of the finance minister has been long overdue. The finance minister should have left that position 2 years ago. And Mr. Speaker, I will prove to you that the finance minister has effectively and fatally mutilated the laws under which he is supposed to govern the financial affairs of our country. Mr. Speaker, it is very sad that the finance minister at committee tried to explain to us that he paid capital expenditure that have multi-year implications on our finances from the contingency fund. Mr. Speaker, the finance minister knows that the Public Financial Management Act is his Bible. And the Bible quite clearly provides safeguards that he is aware of. And Mr. Speaker, I would like to refer to the Public Financial Management Act, particularly Article 33, Section 33(1). Mr. Speaker, 33(1) says, a covered entity shall not enter into any agreement with a financial commitment that binds the government for more than one financial year. For more than one financial year, or that...
Honorable Adungo, just a minute. Deputy Majority Leader, don't worry.
Mr. Speaker, you have said time without number that we must accord each other with respect, ensure decorum in our language. Mr. Speaker, when he started this debate, he said he is not a lawyer, but what he said he's just heard. Okay, Mr. Speaker, he cannot impugn that to me. Mr. Speaker, we must not allow that to happen. And I want to, Mr. Speaker, I want to pray you to get him to withdraw. If he disagrees with me, Mr. Speaker, if he disagrees with me, he's free to say so. He cannot use foul language to express his disagreement of what I have submitted on the floor. Mr. Speaker, he should withdraw. And Mr. Speaker, if we want to have a good debate, he would have to choose his words carefully. And Mr. Speaker, I can only invite you to call him to order, withdraw and apologize. We are talking law. If you disagree with the legal submission, say so. But don't try to spite somebody. I will not take that from you, Honorable Adongo. With respect, I will not. And Mr. Speaker, I can only call on you to get him to withdraw.
Honorable Deputy Majority Leader, you are completely out of order. That throughout my reading of proceedings of the House is permitted. And it has been stated a number of times here in this floor. And my very good friend, the Majority Leader, has said it many times that he's not a lawyer, but he knows more than lawyers on a number of occasions on the floor of this House. So, please. Yes, Majority Leader.
Mr. Speaker, with the greatest respect to the chair, and I do know that you know that speakers are not to participate in the debate. Having said so, now that we make this allegation against me, that I've said this on the floor of the House, with the greatest respect, can you provide evidence? Here. Can you provide evidence, Mr. Speaker?
Honorable Majority Leader, Mr. Speaker is not participating in the debate. I have been called upon to give a ruling. I gave the ruling and had to support the ruling by reference to what I know and what I've experienced. I'm not participating in the debate. So, Honorable Isaac Adungo, you may continue.
Mr. Speaker, I was on my feet to explain how the finance ministers have violated the Public Financial Management Act
particularly in respect for the expenditures on the National Cathedral. Mr. Speaker, the National Cathedral is a capital project with multi-year financial commitment on the state. And Mr. Speaker, the Public Financial Management Act provides the rules under which such activities must be carried out. And under Section 33(1, Mr. Speaker, with your permission, I quote, a covered entity shall not enter into any agreement with a financial commitment that binds the government for more than one financial year, or that results in a contingent liability, except where the financial commitment or the contingent liability A is with the prior written approval of the Minister for Finance, what we call the commencement certificate that you issue to commit to multi-year transactions. Then 2, authorized by Parliament in accordance with Article 181 of the Constitution. Mr. Speaker, there is a reason why the Finance Minister is required to give a prior written approval, so that it is known to the state, it is added to our multi-year expenditure framework, so it is properly budgeted and appropriated for every year. How come a transaction can be a contingency for 3 years? A capital project becomes a contingency for 3 years under a finance minister. Mr. Speaker, 2019, you spend on that project. You still have not issued a commencement certificate or an approval to commit to the multi-year. You have not added it into a multi-year expenditure framework. You are not appropriating for it. The following year, it is still an unknown project that you spend on a contingency. 3rd year, you still spend on a contingency, and you still want to be a finance minister. For what? Mr. Speaker, this is a blatant breach of his own Bible. Mr. Speaker, the Public Financial Management Act provides that in preparing the budget and committing the state to certain resources, the finance minister must issue a comprehensive report on the fiscal and macro-fiscal risk on the state, indicate the debt sustainability and contingent liabilities. Mr. Speaker, today, the finance minister is saying that for the past years, he is not preparing the fiscal risk statement, he is not preparing the debt sustainability report, and today investors are losing their monies because of his recklessness. Mr. Speaker, the capital market collapsed, and he announced the funeral. And the man still wants to sit there when pensioners are losing several years of their monies. Mr. Speaker, as we speak today, people are crying. There's a rush on our financial system. All because the finance minister failed to comply with Section 15 of the Public Financial Management Act and should have taken steps to ensure that our debt is sustainable. Mr. Speaker, this man should have left yesterday. I don't even know why we are still discussing. Mr. Speaker, the recklessness,
Honorable Member, the rules don't allow you to refer to a colleague as this man. No, you have to withdraw that and apologize to him. You don't say so.
No, the finance minister should have left yesterday. But Mr. Speaker, on the voices of the recklessness of the finance minister, that has led to the collapse of the city. That has led to inflation at 40%. That has led to interest rates in excess of 40%. It's all down to the finance minister. Mr. Speaker, I have a document from the Bank of Ghana. This document I will tender in evidence. The document is labeled Bank of Ghana response to statement by Honorable Isaac Adongo, and that statement hangs the finance minister and hangs the governor of the Bank of Ghana. Mr. Speaker, in that statement, he provides a table. In that table, he says that this year alone, 91.8 billion has been borrowed by the finance minister from the Bank of Ghana. Mr. Speaker, when you borrow 91.8 billion and spend on that economy, you create inflation. You distort our inflationary targeting framework because those monies are now being converted into dollars. Mr. Speaker, in an attempt to recall that money back to Bank of Ghana has increased the policy rate now up to 27%. The banks are now charging, he himself is now borrowing at 36%. So businessmen are now borrowing at 40%. Mr. Speaker, the depreciation of the cedi is in direct response to the injection of monies that were illegally borrowed by the Minister of Finance. Mr. Speaker, the Bank of Ghana law is quite clear that at any point in time, the total exposure or claim on government should not be more than 5% of the previous year's revenue. Mr. Speaker, all of your revenue last year was 991 billion. Not to talk about 5% of it. So when we say you have recklessly mismanaged the economy to lead to inflation, this is where the evidence is. If we say that it is your mismanagement and recklessness that has led to high interest rates, this is where the evidence is. And Mr. Speaker, when we say that you are the cause of the depreciation of the cedi, it is not far from this. Mr. Speaker, the finance minister has failed us. The finance minister has made us lose our money in the capital market to the extent that now he is saying that investors will not even get 31 billion Ghana cedis that is due them as interest payments. Mr. Speaker, investors will not get the capital that they gave to us. What we have failed to realize, Mr. Speaker, is that our relationship as a government to our people is born out of the trust and the confidence in the sacred trust of our government. And when governments cannot be trusted, when government cannot be trusted to pay back the loans, then no government will ever be able to get a penny from the people of Ghana to fund our economy. And he would have left that legacy that will make no government, not even if we go to bring Donald Trump here, he will be able to get a penny from our investors in Ghana. Because they will not give you the money because government cannot pay. Mr. Speaker, it is quite clear. It is quite clear that beyond all of this, I am surprised that we are saying that we shouldn't discuss conflict of interest. Mr. Speaker, is it not true that he owns Data Bank? Is it not true that Data Bank is the one who is a transaction advisor and a book runner borrowing for government? Is it not true that Data Bank is paid fees that he gets dividends from? It is true. So what is it about the conflict of interest that we should not be discussing here? Mr. Speaker, is it the only financial institution in Ghana? Why is it that before he became a finance minister, Data Bank was not a book runner? Why is it that suddenly you are everywhere in that bank? Why is it that now Data Bank Enterprise Group, they are now the only financial institution that are taking every business? And you are saying that we cannot discuss conflict of interest. We need to set standards for our country. We need to ensure that Ghanaians take us serious and that when we are giving jobs, it is not to grow our businesses. It is to serve the people and to make sure that Ghana becomes the winner. Mr. Speaker, if anybody continues under this to contend that the finance minister should remain in government, then we must as well dissolve Parliament and dissolve government as well. Because we are failing our people, we are failing the people out there who voted for us, and we are failing the people that we are supposed to serve. You cannot be serving yourself. You must serve the nation, and you have failed. It's time to say, Ghana, you gave me an opportunity to serve you. I have served you to the best of my ability. My ability is not good enough. Bring in somebody else to do the work. Why are you still sitting there? We gave you the job. We said we don't know you again. Is it false? Is it false to serve us? Is it false for you to serve us? So please, the finance minister must do the honorable thing and leave that office and give us an opportunity. Thank you very much, Mr. Speaker.
Honorable members, honorable members, I'll be compelled. Honorable members, I'll be compelled to name members and to order the marshal to pick the member and take him out. I say I'll be compelled to do so. It's permitted by the rules. We are debating a very serious motion. You are making serious statements. You are calling the people who voted for you to be here, to be part of it, and to also take a decision. It is not a playground or a dancing floor. This is a serious national political platform. That is the highest in every country, the parliament. And so it's serious business. It's not a joking matter. It's now the turn of Honorable Samuel Abu Jinapok.
Mr. Speaker, Right Honorable Speaker, I thank you very much for the opportunity to contribute to the debate on this motion, which you quite rightly pointed out is a very important matter. Mr. Speaker, we are gathered in this chamber to take a decision on the fate of the Finance Minister through this motion of censure. Mr. Speaker, may I respectfully submit that motions of censure among motions constitutes one of the most important, grievous, consequential motions that can be brought before a parliament. Mr. Speaker, they are not put before a house lightly. They must be well motivated. They must be on solid grounds. They must be on grounds which suggest that a minister who has been nominated by the president, who's received the prior approval of parliament, and who's been appointed by the president, the parliament itself is now sending a message to the president that the president should remove such a minister from office. Mr. Speaker, if you indulge me, in the American Constitution of 1789, Mr. Speaker, the motions of censure against their own members of Senate, Mr. Speaker, have only been invoked since 1789 9 times. Mr. Speaker, it tells you the gravity of motions of censure. Mr. Speaker, in the House of Commons, Mr. Speaker, in the House of Commons in the United Kingdom, ministers of state were hitherto impeached. The process was found to be cumbersome, and subsequently, the impeachment procedure was replaced with motions of censure. But, Mr. Speaker, even in the House of Commons, it is invoked to reprimand the minister. And even when it is invoked to reprimand the minister, Mr. Speaker, it is rarely invoked. Mr. Speaker, I make these points just to establish the point that the exercise we are engaged in here today is a very important exercise. Mr. Speaker, the precedent we set today will guide this House, will guide subsequent governments, will guide our country and its democracy. It may be somebody else from the other side, it may be somebody from our side. And so, Mr. Speaker, the grounds on which the Minister for Finance is being called, or the grounds on which the motion seeks to censure the Minister for Finance, must be well grounded. Mr. Speaker, that is why I want to respectfully refer the House to the report of your ad hoc committee, which has been laid before this House and which should guide all of us. Mr. Speaker, the first ground on which the proponents of this motion is calling on this House to censure the Finance Minister, Mr. Speaker, if you allow me, I'll read it. Ground 1 says, despicable conflict of interest, ensuring that he directly benefits from Ghana's economic woes as his companies receive commissions and other unethical contractual advantage, particularly from Ghana's debt overhang. Mr. Speaker, the ground is on conflict of interest. And Mr. Speaker, if you allow me, I will refer the House to the case, the celebrated case, and the locus classicus of Okudioto Ablako and another, number 2 versus the Attorney General and another, number 2, 2012, 2 Supreme Court of Ghana Law Report at page 845, where Brobe JSC, in commenting on conflict of interest, had this to say, Mr. Speaker, and I quote him, and it's in the report. The complaint of conflict of interest made by the plaintiff against public officers, all the officials of the Lands Commission, and those of the Ministry of Water Resources, Works and Housing, will be dismissed because specific remedy has been provided under Article 287 of the 1992 Constitution, which requires complaints of conflict of interest against public officers. It goes on and on. Mr. Speaker, the point I seek to make, this is the ground on which our friends, our honorable friends from the other side, are inviting this House to set a precedent for the censure of the finance minister. Mr. Speaker, respectfully, I will submit that this ground is weak, and I think that the committee itself recognizes that, and that this cannot be a ground on which, a serious motion such as a motion of censure will be led to remove a finance minister. Mr. Speaker, I take you to the report again, and I take you to ground 3, the third ground on which the motion of censure is hinged. And Mr. Speaker, that ground indicates illegal payment of oil revenues into offshore accounts in flagrant violation of Article 176 of the 1992 Constitution. Mr. Speaker, the committee itself, in commenting on this ground, ground 3, and the ground on which they are calling on this august House of Parliament to censure the finance minister, the committee itself had this to say, and I quote, Mr. Speaker, it's found at page 22 of the report. The committee, having regard to the above evidence by PIAC, that they could not confirm that the Minister for Finance was responsible for the non-payment of the oil liftings by John into the PFH, and the evidence of GMPC that the payments were made into JOHL's offshore account by the buyer of the crude under the instructions of JOHL, and that the Minister for Finance played no role, decided that the Honourable Minister was not enjoined to lead evidence in defence of the said ground 3. Mr. Speaker, this is what we are being invited to participate in. This is what the committee itself, your own ad hoc committee, made the finding on ground 3 that the finance minister played no role. Mr. Speaker, and I can go on and on and on. If you want, I'll take you to ground 5, where they talk about fiscal recklessness leading to the crash of the Ghana cedi, and it goes on, and the finance minister responds very copiously, comprehensively, and the response is captured in the report. Mr. Speaker, so all the grounds, beginning from ground 1 to ground 6, as captured in this report. First of all, ground 1 itself was legally untenable, was unconstitutional, could not be entertained by the committee. The committee itself jettisoned ground 1. The Speaker, ground 3 itself, the committee actually asked the Minister for Finance not to lead evidence on ground 3, because they themselves had found out that the proponents of the motion were erroneous, including ground 3 into the grounds on which the motion was brought. Mr. Speaker, the conclusion of my submission, really, Mr. Speaker, and I say this with a lot of passion, that what we seek to do in this House and the decision we take on this motion must be well motivated. Because, Mr. Speaker, today it is Finance Minister Ken Ofori-Atta. Tomorrow it may be Finance Minister Atuforsen. Someday, it may be someday. Mr. Speaker, I want to contend. Mr. Speaker, I want to contend that today, for political expediency and for political scoring, it may be Minister Ken Ofori-Atta. Mr. Speaker, 20, 30 years from now, it may be the turn of Finance Minister Atuforsen. Mr. Speaker, when that day arises, if it ever did, and if I was found on the other side of this House, Mr. Speaker, principle will prevail, facts will prevail, evidence will prevail, propriety will prevail, and I will not support a motion of censure on this nature, which seeks to censure a minister when it is not well grounded. Mr. Speaker, the whole country, thankfully and mercifully, the whole country saw the finance minister before the committee. And I have a lot of respect for this House, so do I for the committee. The committee did a great job, and the committee is a distinguished committee of this House. But clearly, any objective-minded Ghanaian cannot help but come to the conclusion that Finance Minister Ken Ofori-Atta distinguished himself before the committee, that he acquitted himself, and that he demonstrated beyond doubt that he's in full grace and full command of the Ghanaian economy, and that the measures he's putting in place, Mr. Speaker, just as his party and government did from 2017 to 2020, when we inherited an IMF economy, and when all the macroeconomic indicators and indices were in disarray, but we brought it back on track and took this country on growth and prosperity, that this finance minister and the economic management team of the government and the government of President Akufo-Addo is doing just that. So, Mr. Speaker, in conclusion, I urge my colleagues, Mr. Speaker, in conclusion, that we take these matters very seriously. These are grievous, weighty matters before this House. The country is watching us. Africa is watching us. And I should indeed say the world is watching us. Because Ghana is a beacon of democracy. We continue to be pace-setters. A motion is being put in place, but it is clear that this motion is not well grounded. It is clear that the pillars on which this motion was moved are weak. Ground one is being rejected. Ground 3, the committee itself did not even take evidence on it, and the other grounds are not well motivated. And therefore, Mr. Speaker, this motion should fall and fail. I thank you, Mr. Speaker.
Honourable members, it's now the turn of Honourable Dr. Atu Forson.
Thank you, Mr. Speaker. Mr. Speaker, there's always a first time for something. Mr. Speaker, it is indeed the first time that Ghanaians are being called upon to have a haircut. It is indeed the first time that an African country had to restructure its domestic debt. So, Speaker, since Mansa Musa, this is the first time an African country is being called upon to shave off its interests. So, Speaker, it is in the same vein that this is the first time that there is a censorship motion before us since 1957. So, Speaker, it is for a good reason that we in the minority believes that our Minister of Finance needs to go. The Speaker, it has nothing to do with his personality, but it has to do with his management style. Speaker, we believe that all what Ghana is going through was avoidable and is still avoidable. Mr. Speaker, first, let me talk about the fact that since 2018, our minister has been consistently misreported to Parliament. So, Speaker, to surprise you to know that our minister had reported to us that in the year 2018, the fiscal deficit was 3.9% of GDP. Simply put, he had to borrow 11.6 billion Ghana cedis to fund an excess expenditure. So, Speaker, again, after informing Parliament, he had gone to inform the IMF that indeed Ghana's fiscal deficit was 7.1% of GDP. Simply put, he borrowed 21.4 billion. So, Speaker, he borrowed in excess of almost 10 billion Ghana cedis without recourse to Parliament. So, Speaker, again, in the year 2019, even though he had informed us, we in Parliament, that the deficit for the period was 4.8% of GDP, the actual fiscal deficit as he presented to the IMF was 7.1% of GDP. Simply put, he borrowed in excess of appropriations by 8.3 billion Ghana cedis. So, Speaker, this practice continued in the year 2020, continued to the year 2021. So, Speaker, in the year 2021, he had informed us that he did fiscal deficit of 11.7% of GDP. So, Speaker, this means that he borrowed 44.9 billion, but actually, he ended up borrowing 67 billion Ghana cedis, almost 20 billion more than what Parliament approved for him. So, Speaker, I believe that Ghana is going through what we are going through, largely because of the fiscal recklessness we have seen since 2018. So, Speaker, I still contend that what we are going through was avoidable. But unfortunately, our minister decided not to listen to anyone. So, Speaker, what surprises me is that if you are to track the fiscal part, among 46 African countries, Ghana has the worst record in terms of fiscal management. Worst record in terms of fiscal management. 46 African countries. So, Speaker, this is sad. This is shameful and it's not acceptable. So, Speaker, clearly, we are where we are, mainly because of the attitude of the fiscal managers. So, Speaker, clearly, this management, the management of our economy, have disappointed the people of Ghana. So, Speaker, let me recap and let the people of Ghana be aware that our minister responsible for finance clearly breached the Fiscal Responsibility Act 2018. The Speaker, the Fiscal Responsibility Act in Section 2 says clearly that despite the fiscal responsibility indicators stated in Section 16 of the Public Financial Management Act 2016, Act 921, the following numerical fiscal responsibility rules shall apply in the management of the public finances. The Speaker, A says that the overall fiscal balance on cash basis for a particular year shall not exceed a deficit of 5% of gross domestic product for the year, and went on to say that an annual positive primary balance shall be maintained. The Speaker, Section 4 says that Parliament may, in accordance with Article 82 of the Constitution, pass a vote of censure on the minister where the minister breaches Section 2 by more than 1 percentage point. The Speaker, clearly, in the year 2018, the minister breached the Fiscal Responsibility Act. In the year 2019, again, he breached the Fiscal Responsibility Act. The Speaker, what surprises me is that at the committee, the minister's answer was, there was a budget before us, and that budget was approved. The Speaker, what I did not hear from members of the committee was for him to ask, what did Parliament approve? The budget that Parliament approved was not for the minister to do a fiscal deficit at 7.1% of GDP. Was for the minister to do a fiscal deficit of 4.8% of GDP. So he spent in excess of appropriation in the year 2018 and 2019. So, Speaker, clearly, the train for this censorship motion moved in 2018 and 2019. Our minister responsible for finance should have left the Ministry of Finance 2 years ago and not now. The Speaker, clearly, the time is now for our minister to leave the Ministry of Finance. For a simple reason that he has destroyed our livelihood. The Speaker, this is a minister who inherited debt to GDP of 55.6%. 55.6%. At the time, there were no ESLA bond. At the time, there were no Sino-Hydro loan. So, Speaker, at the time, we were not having, Dachi bond. Mr. Speaker, at the time, clearly, cocoa bills at the cocoa board was less than 1.2 billion Ghana cedis. Mr. Speaker, when he became the Minister of Finance, arrest owed to contractors was under 2 billion cedis. 2 billion cedis. The story today is far worse. Debt to GDP is in excess of 100%. To be specific, 110% of our GDP. From 55% to 110% of GDP. In 6 years. So, Speaker, today, if you go to Cocoa Board, the 1 billion cocoa bills has all of a sudden become 15 billion Ghana cedis. 15 billion Ghana cedis. So, Speaker, again, he informed us in the budget, Appendix 3B of the 2023 budget, that he owed contractors 37 billion Ghana cedis. From 2 billion to 37 billion Ghana cedis, all within 6 years. So, Speaker, how? How could you manage an economy like this? So, Speaker, the manner in which our economy has been managed is reckless. So, Speaker, reckless is an understatement. If there's any other word, I will use it. So, Speaker, we are where we are because of the duties that they gave to the minister. He has mismanaged it. Speaker, clearly, the time has come for our minister to leave. So, Speaker, let me say this. I've heard that our colleagues from the other side want to boycott the voting. The Speaker, the people of Ghana are watching you. The people of Ghana are watching you. You cannot You cannot do this, Mr. Speaker. In one breath, when you meet us at the corridor, you tell us to vote for the minister, vote against the minister. But in another breath, you are not bold enough to stand here and vote against him here.
Dr. Atufos. Yes, a minute. Yes.
Thank you, Mr. Speaker. I think this is an honorable House. As we are conducting this exercise, Ghanaians are watching and listening to us. So our comments should reflect the truth. My colleague, Dr. Atufos, made a statement that is very misleading. This is the budget we have. About 37 countries, 2022 GDP, they are below. 2022, below that of Ghana, 5%. So the statement that he made, that about 46 countries in Africa, what we have is misleading, cannot be true.
Honorable member,
Mr. Speaker,
there is no point of order. Please, you are debating. You are debating. This is not point of order. Please, you may go.
Mr. Speaker, for the records, I was talking of fiscal part. He's talking of GDP growth. And let me assure you that fiscal part is different from GDP growth. So for your education, take note that fiscal part is different from GDP growth. Mr. Speaker, it is clear that our economy has been mismanaged. Mr. Speaker, it should be noted that if you are to meet an average Ghanaian or ordinary Ghanaian, their wish is to leave the country. Sadly, their wish is to leave the country. So, Speaker, if we do not act now, we will wake up one day and we will not have constituents. So, Speaker, almost everybody will leave our country to Togo and we'll have no country if we fail to act. So, Speaker, people want to leave the country. Simple put, there is a responsibility on our shoulder to save our country. And I call on you, the majority, to join us, the minority, to do what is right. So, Speaker, we will go any length to protect the people of Ghana. We believe that the livelihood of the ordinary Ghanaian is at risk. The livelihood of the ordinary Ghanaian is at risk. Inflation has increased from 13% to 40% plus within 10 months. So, Speaker, the cedi has depreciated by 54% within 10 months. So, Speaker, what is happening here has never happened in the Fourth Republic. Let us take note and let us be aware that one of the ways that we can get back to where we were is to get the minister out. We need a fresh minister who will come with a lot of confidence. The international community has lost faith in the economic management. And that is why, Mr. Speaker, I call on my colleagues to join us. Please join us. Don't run away from your responsibilities. Don't run away from your responsibilities. Vote for Ghana. Don't vote for your party. If you are to leave, you have run out of Ghana. Your constituents are watching you. So please vote and let's change. Mr. Speaker, to conclude on this one, Mr. Speaker, to conclude, let it be noted that our minister has mortgaged our future. He has mortgaged Energy Sector Levies Act. He has mortgaged cocoa trees. He has mortgaged almost everything that this country has. We cannot continue like this. We cannot continue like this, Mr. Speaker. Today we are being called upon to have a haircut. They are expropriating our assets. And that is for the reason why we are where we are. Please, Minister, the time has come for you to say bye-bye to the Ministry of Finance. Say bye to us and give someone an opportunity to fix the mess that your administration has created. Thank you, Mr. Speaker.
Honorable members, I'm compelled to suspend proceedings for 10 minutes.
personality profile this Friday.
It was tough. The first 2 years of my time in St. Peter's, I literally lived in my desk because I was bullied so much.
Goodness.
I fought once.
They must have pushed you to the wall.
Yes, this was a guy who...
Ken Ofori-Atta must leave office. Indeed, we've heard from board members on both sides. When they return, the Attorney General is around, the Minister himself is around. We'll be seeking to hear all of them. You've heard from the New Patriotic Party side. They've been led in their debate by the Deputy Majority Leader in the person of Alexander Afenyo-Markin. We've also heard from Samuel Abu-Jinapor, the Minister for Lands and Natural Resources. They've all been making some spirited arguments for the Minister to continue to be in office. We've also heard from the minority. The argument started from Isaac Adongo. He's the Deputy Ranking Member on the Finance Committee, stating that the Finance Minister must go and he should give the country the chance to get back in terms of fixing the economy. We've just heard from the Ranking Member himself, Dr. Kisela Toforsen. But first, you heard from Mr. K.T. Hammond, who moved the motion for the committee to the report to be adopted. Then we later also heard from the deputy, the other co-chair, that is Dr. Dominic Ayine, who sort of laid the grounds for some of the things we've been hearing so far. And in his perspectives, he said that a finding conclusive had been made that the minister had misappropriated funds and that the minister had misreported data to Parliament and that there was also misconduct on his part. So this debate is going to continue when the House returns from their break. We are going to hear from 3 more members on the minority side, 3 more members from the majority side. The leadership will be the ones to conclude the debate before a vote will be taken. What we've heard so far from the New Patriotic Party, they've asked their members not to participate in this vote. We do not know yet if they will be doing so, but that statement signed by the General Secretary of the party as well as the Majority Chief Whip, Frank Anodompreh, advised members of the NPP caucus in Parliament not to vote when it's time. So very soon we will see there, just beside the Speaker, the Electoral Commission's insignia and their tools for the vote to take place. But it's been spirited debate. The debate is still happening on the floor. Well, although the House has just taken a break, when the House returns, the debate will continue. But spirited debate happening from among the MPs who insist from the minority side that Ken Ofori-Atta must lose his job, he has mismanaged the economy, and that he is guilty of the 7 grounds that the minority have laid against him in their censure motion. So stay with us here on Joy News. After this break, when the Speaker of Parliament comes back and the House is gaveled in session, we'll bring you some further details on this censure motion that the minority have filed against Ken Ofori-Atta as Finance Minister.